The next author is a professor of Oxford University, was Hebert Hart, very influential all over the world, very influential. These are very influential, all of them, and that's why we are checking all of them. So this is Hebert Hart. He is in this line, positivism, and he promoted positivism. He had an oversimplification of what is natural law. For him, natural law is law plus morality. It's not just something reasonable, no. It's not the thing that we mentioned in the classics, no. He didn't got so deep in the classics. It's just law with morality or without morality. He said, well, I want that every law should follow morality, but it's not the same, no. He will say at least a minimum of natural law there should be, because otherwise the law will be, the society will be a suicide club. That is the famous phrase of a minimum of morality, a minimum of natural law should be in the legal system, but it's two things different, no? He said. So he realized that Kelsen was not so clever, not any of the neo-Kantians, the followers that say that law is a command backed by a sanction. No, law is something more than a decree of a gunman, a command backed by a sanction. No, it's something new. There is something new. And he's more or less in the same line of Pond, no? Roscoe Pond, that says lawyers and judges are engineers, so it's a kind of plan to create welfare. It's a plan that achieves the common good. He will say these are words of Hart. It's a generalized plan or plan-like norms issued by those who are authorized to plan for others. You realize there are people with power that can bind you, but why they approve this? Not just to bother you. No, they want something good for the community. The classics will say the common good. Okay, that is interesting, and that's why you answer now. Why you obey the law? Because I think that could be something good. Could be peace. Could at least nobody will crash if you follow the rules of traffic and so on. No? Now, he distinguished two kinds of rules: primary and secondary rules. What is the difference between them? Well, some of them will create the standard and others will create the rule. Or, I mean, the process of new rules. Let's see what I'm talking about, and I will explain you again. So, for Hart, the rule is not a mere habit. No? Malinowski, do you remember? The professor of Jomo Kenyatta that was here in Kenya and was living with the peoples, and in the Trojan Islands, he realized that law is a function. Everyone is doing that. That isn't a habit. Can you see it? A habit? You are habituated to do that, and that's why that is the law. He said, no, law is not a habit. Indeed, when a law is approved, nobody is habituated, is doing that. No? So it's different. No? It's a manifestation of our actual behavior, our words, and our thoughts. No? Yeah, if society thinks in that way, that will be the rule. So he realized that there is a social dimension of rules, no? A manner in which members of a society perceive the rule in question, the attitude towards it. So he is living after Elric, after Eugene Elric, after Roscoe Pond, and he realized that one is the norm in books and another in reality. One is the norms and decisions, and another the living law. No? So here, like that, this is a social dimension of rules. No? So, and that is important to discover what is the law. So at the same time, so there are secondary rules that puts exactly how the law will be issued, approved, included, appear in the legal system. No? The primary rules are the standard, the thing that you should do, you cannot do, you are allowed to do. The secondary rules is how the primary rules are approved, are created. No? So the rule of change. No? So customs about law should be changed. Confer power to enact laws following certain process as well. The parliament, for example, can approve new laws because the constitution contains the rule of change. How you change your laws in Kenya? Well, there should be a procedure in the parliament, 2 debates, then the approval of the president, and so on. Can you see? That is the rules, how you change your laws. The rules of adjudication. Now let's see, think more in the judiciary. No? Confer competence on individuals to pass judgment in the judiciary. No? You don't know if you have that power, right, or duty. You ask the judge, and the judge will answer. Can you say? So it is easy, no? It's a kind of ruling that says this guy will decide your case and will adjudicate the thing, the right, the duty, or not. Yeah, this is normally associated with a power to punish. Also could be the criminal judge, no? Who can put you in prison, can put you in prison. And now, the most important secondary rule, and probably the most important rule for Hart, was this one, the rule of recognition. The rule of recognition. So, what is this rule about? It is easy, but sounds a bit strange. No? How you recognize who is the authority or which rules are good. Some people believe that this is a kind of effort of including a kind of natural law or a rational approach to law. So, for example, if you ask people in the street, no, do you think that that law is just or not, is valid or not? No, it's not valid because it's killing so many people, it's unjust. So, yeah, so, but is that the law or not? Is that the law or not? Remember, we are dealing in this author now with the concept of the living constitution, law in books, law in action, all the previous things that were discussed in the previous authors. So he said, well, the rule of recognition is the ultimate criteria of validity of the rules of the legal system. So that was a kind of, do you remember the hard questions of Kelsen? No, why the grand norm is valid? Because something else that is not in the pure theory. No? Well, it seems to be that this is related to that, to the values of society, what the society thinks that is good, just or unjust, valid or invalid law. However, at the end of the day, the answer of Hebert Hart to this question was more or less in a very positivistic way. Say it can neither be valid or invalid, but simply accepted. This is what the society accepts. But when do you find? Where do you find that the rule was accepted or not? He said, is what the Queen in Parliament enacts is law. So if the judiciary, if the Parliament, if the Queen approves as law, that will be the law. That will be the law. So The rule of recognition at the very beginning seems to be something that gives the power to society to put their own law. No, and at the end of the day, it's the same things that we mentioned. No? What is the law? What the parliament, the executive, or the judiciary approves as law. Can you see? Or standards, or rulings, or whatever you want. So there is nothing new. It was a kind of effort. Some people will critique Hebert Hart because that was a very narrow point of view of the rule of recognition. Okay. The authority of law is social. He tried to give a social dimension to the law, but he was not able for many to do that because everything is circumscribed in the law. So let's talk about now the rules of adjudication. He has a very interesting approach here to the rules of adjudication. By the way, if you have any questions, you can drop me that question in the chat and I will try to answer. Okay. So the rule of adjudication is a secondary rule that shapes how the norms will be. I'm just repeating. It confers power to the judiciary, judges, and perhaps some other people to punish, to adjudicate things, rights, duties, and other things could be provided. Okay, so he puts one example. He puts one example to explain a difference between the formalization of the law. It could be just a formal approach to the law or a more discretional approach to the law. That are the two extremes. No? The formal approach, you just read the law, try to understand what are the facts, and conclude. Immediate conclusion is like a mechanical label. Yeah, probably artificial intelligence can do that now. Yes, it's a very formal approach to law. The artificial intelligence cannot decide. No, they have tons of possibilities. If you have many possibilities, that is the streaming role. It's a discretionary role. The judge can do whatever he wants. These are the two extremes. When you use this road or the extreme road, well, he will put this example. No vehicles in the park. You are walking in the park. It's Sunday, a beautiful day, a sun that we have now, that day, no? And you read in front of you, no vehicles in the park. Probably you understand, I hope so, what is about that sign, no? So first question, yeah, and let's suppose that you are the police. You are the police. Yeah, then when you are walking in the park, someone's appear with this vehicle. So if you are the police, what you will do? You will say, stop. I think so, no? Look, you cannot be here in the middle of the park. You are driving in the middle of the park. I mean, you will kill people. No, there is no one. No, but it's not allowed. They will find you if you don't go away. Okay? Is that a vehicle? The question is that vehicle? Seems to be. Okay? Perfect. Second question, what about this? So you are the police and someone shows up there with a bicycle. So is the bicycle a vehicle?
I would say it's a vehicle because well, it depends on what a vehicle is, but it is used for transport. But yeah, I think I'm
So
sure it's
you
a
will
vehicle, but I
ban,
would
you
say
will
that yes,
ban
it is a vehicle.
the bike rider, you will ban. You cannot be here. Look the sign. Will you ban that? Forbid.
Well, uh, yes, I want to say yes, but it again also depends on why the law is there.
Yeah. Why is
If the okay, now maybe I'll change my answer, but if the law is because we do not want to pollute the park, and vehicles that use fuel are going to pollute the park, but a bicycle is not using fuel, then I would allow them to be in the park, but objects of the law. I don't know.
so you change the notion of vehicle because they just realize that the words were written for something, no? So let's put another example. Now you realize that some guy is running so fast in the motorbike. Is a motorbike a vehicle or not?
I think so, because I mean, a motorbike has an automotive engine, so I would guess that would automatically make it a vehicle because it has two wheels and an engine.
Yeah. Yeah, well, it seems to be in this case that is a vehicle. Yeah, yeah. But what about the bicycle? There are some bicycles that have a small electric engine that helps the guy to go faster. Is a typical bicycle. You also go back to my answer. Yes, a motorbike is a, yeah, Alicia. Okay, so yeah, so that is interesting. I don't know. And what about a simple bicycle that a simple bicycle that has a motor, a small motor that allows you a bit more speed, a bit more help in the hills? Is that a bicycle, a vehicle or not? So let's put one last example. No? Bob, you realize you're the police. Now Bob is with his skate. Is there. Do you think that if you're the police, will you stop Bob or not? Is the skate a vehicle or not?
I don't think it falls under a vehicle category. I don't know, the rollerblades. So I don't think it's a vehicle. I don't know how to explain it, but I don't think it's a vehicle. I don't know how to explain it, but it's not a vehicle.
Okay, will you ban Bob? No, because it's not that, no? Yeah, so why I put these examples? Why is why you stop these guys or not? Just because the things that are there, vehicles in the park? No, because you realize that this sign probably has some purpose, no? A specific purpose, no? What is the purpose of this sign? What is the purpose? Why the authorities put this kind of signs? Probably is because in the park many times there are families. There are some families or children playing. It will be risky for them. It's a big car is crossing, and you see, or a motorbike that can be a very incredible speed is crossing. There will be not that much risk with Bob. I will say no risk, no. Probably for Bob, yes. but yeah, or in a typical bicycle, there will be no risk, and it's the typical thing that people do in parks. No? Driving, riding a bicycle or using a case to have fun, to have fun. And you see, so that is the reason. So isn't there the same phrase? Yeah, a reasonable man rule. Yeah, the same phrase can be read in many ways. And he realized, Hebert Hart, that the text of the law is open. It's not just you should do that and you should apply. There are some cases, and yes, you should apply, and it's very clear what you have to do. And you will just formalize what the law says in this case, apply to this case, and you are driving a car, you cannot be here. That is, he will say, an easy case. An easy case, and the approach to easy cases is just to formalize what the law says. And you see? But there, an easy case also is the contrary, both, no? Both. That seems to be a vehicle. No, probably it's not a vehicle. I don't know how to say it, but the answer of Yvette, yeah. And many people say, no, I don't know, but it's clear that this is and this is not. Yeah. That's why these two are easy cases. Instead, there are some hard cases, which there is more penumbra, obscurity, darkness. Probably it could be the same text, but you don't know if that text applies. Is a variety of grays. So let's think in that bicycle that has a small engine, an electrical engine that allows you to go farther, a bit faster, and to climb hills. This case allowed, well, according to Hart, in hard cases, you can do whatever you want. If you're the police, you can say, yes, you can stop, or you can say, okay, don't worry, do whatever you want. It's discretionary. The police can do whatever they want, because it's not clear. So in easy cases, you should apply, and you in a formal way, like a machine, and probably artificial intelligence will do that today. No, in hard cases, you can do whatever you want. Okay, that is more or less the idea. And he will even add a bit more of information. He said, between these three cases, hard cases could be a middle case. So that's why when the case is harder, you have more discretion. If that is an easy case, you have no discretion. Isn't that is a middle case? Well, middle discretion, more or less, is the idea. It's very interesting, Hart. So strong middle and weak discretion. You know?